sentencing the defendant, myself or Judge Collier up in Medina County Common Pleas, Judge McElvain here in Wadsworth, we actually have the least, if the person doesn't go to trial, if they change their plea after they're brought to court, they go from a plea of not guilty, which they initially made, to one of guilty or no contest, we actually have less time with them than almost anybody else in the system. We spend less time than the officers do usually. We spend less time than the defense lawyers do. We spend less time than the probation department does. If a person comes in front of us, gets indicted, comes in front of us for an arraignment, then changes his plea, and then comes back for sentencing, the total amount of time they spend in the courtroom may be well less than 30 minutes.
I see.
So you have to have the PSI because we just don't know enough about the person to make an intelligent sentence. Now, what's kind of interesting is sometimes, that's why sometimes, from my perspective, a jury trial, even a non-jury trial, is a good thing to have because it gives me more insight into the defendant because I get to watch them for 3 or 4 days while the trial's going on, see how they react to the trial, see how they react to the victim testifying, things like that, which can give you sometimes an insight into the defendant's thinking. But the PSI is very important.
But if in a jury trial, Judge, and I've observed you on several occasions, and they do sometimes take several days, depending.
Right.
And the jury actually brings back a guilty a guilty verdict. At that point in time, can you call for that PSI then?
Sure. I can do one of two things. I can sentence right from the bench. Jury comes back, enters a guilty verdict, and I tell the jury, thank you very much for your service. I express the gratitude for the community, and then we let them go. I could go to sentencing right then. I've only done it in one case on a felony level. I don't think I've only done it. I did it very few times on a municipal court level on a misdemeanor charge, and I don't think it's a good practice because I usually don't know enough about the defendant to make an intelligent sentence.
That makes sense. Crimes are somehow placed in categories.
That's correct.
Can you explain that?
Sure. There are three. First of all, there's 3 basic categories. There's things called minor misdemeanors, things called misdemeanors, and then things called felonies. Okay. So a minor misdemeanor is a case that carries no jail sentence, and the fine cannot exceed $100. Okay. So, for example, if a person's going 65 miles an hour in a 55-mile-an-hour zone, that's a minor misdemeanor. Fine cannot exceed $100. Then there's the levels of felonies and misdemeanors. And what we used to say was that a misdemeanor carried a jail sentence up to 1 year, and a felony could carry a term of incarceration beyond 1 year. And we used to say that misdemeanors fines stopped at $1,000, and felony fines could be unlimited up to about, well, I think in Ohio about $25,000. To some extent, that's been changed, but this is the difference. I was thinking about this when I was coming down here. How to explain this to your viewers. A felony charge has to be a crime that is committed under state law. First of all,
okay.
It cannot be committed under a municipal ordinance. So it has to be committed under state law, and it has to carry as one of its sanctions a possible term of imprisonment in a state-run penal system.
No county jail.
No, you can use a county jail for a felony, but it has to carry the possibility of going to a prison.
I see.
Okay, so for example, let's say a person was charged, the example I gave earlier, with a felony domestic violence. Okay,
yeah.
I could put them in prison 6 months up to 18 months in 1 month increments. I also could put them in the county jail to what we call residential community control sanctions, but if a person was in front of Judge McElvain for a misdemeanor theft case, that person could never be sent to prison. There is one exception to that, and that is if a person's committed several offenses of violence that are misdemeanors, there is a way they could be put for a short period of time in a state prison system, but generally, to be a felony, it has to carry a state prison sanction.
Okay. All right.
So generally, the people who are in prison have committed felonies, and the people who are in county jails may have committed felonies or misdemeanors.
Okay, so the most significant category would be the most severe penalty would be a felony.
Would be a felony, and then inside the categories of felonies and misdemeanors, there's degrees of felonies. Okay, so for example, there are 5 degrees of felonies in Ohio, and there's 5 degrees of misdemeanors. Okay, if you count minor misdemeanors.
What is that? I mean, let's talk about the felonies. That's
sure.
All right, so we know that the felony is, I mean, that's the worst.
Right, that's the worst of the two groups.
But now,
then inside these, there's categories of offenses. For example, if a person steals a motor vehicle, that's a 4th-degree felony, punishable by 6 to 18 months. If a person steals a credit card, that's a 5th-degree felony, punishable by 6 months to 12 months. If a person commits a burglary, that could be a 1st, 2nd, 3rd, or 4th-degree felony. If a person commits a rape, that's always a 1st-degree felony. If a person commits certain drug offenses, they may be 1st, 2nd, 3rd, or 4th, 5th-degree felonies, depending on the amount of drugs involved. So this is the way I look at it. 1st-degree felonies and 2nd-degree felonies usually involve, not always, but usually involve the possibility of harm to a person. Okay. 4th and 5th-degree felonies usually involve harm to property. Okay. A 3rd-degree felony is kind of like it's kind of like in the middle. In other words, 3rd-degree felonies tend to be crimes, for example, like certain kind of drug cases, certain kind of theft cases, where the harm to the victim is greater than it would be for a 4th or 5th-degree felony, but a lot of times is still not necessarily offenses of violence. Okay, so for example, if a person commits a rape, that's a violent act. That's a 1st-degree felony. If a person commits what's called a gross sexual imposition, that may be a 3rd-degree felony because it can be committed without violence. So what Ohio is trying to do by this categorization is trying to make sure that the state penal resources are used more for 1st and 2nd-degree felonies than they are for 4th and 5th-degree felonies. Okay.
1st and 2nd being against people.
Right, against people like, for example, burglaries, robberies, felonious assault, manslaughter, crimes like that.
That's your 1st.
Right.
That's your heavy hitter stuff.
That'll be your 1st or 2nd.
Okay.
And then your 4th and 5th are like, for example, property crimes, passing bad checks, which can be a felony depending on the amount of money involved, stealing checks, stealing credit cards, stealing cars, committing certain kinds of fraud. Those tend to be 4th and 5th-degree felonies because they usually don't involve as much danger to other people as the 1st and 2nd-degree felonies. And then what Ohio did back in 1996 was, although this has been the subject of a lot of some court decisions that have undercut this, but what they basically did in 1996 was they said, look, judges should presume that 1st and 2nd-degree felonies are going to go to prison, and they should presume that 4th and 5th-degree felonies are going to get probation or supervision. Because what they want to do is, what they wanted to do was to get to kind of, there was a, back in 95 and 96, when they were passing this legislation, there was a lot of concern that people were being treated far differently concerning, given, like you could commit the same type of offense, but depending on where in the state you committed it, you might be sent to prison or you might be given probation. For example, it tended to be that offenses that were committed in rural areas actually were being the most part being punished by prison sentences more than property crimes are being punished by prison sentences in bigger counties.
I guess I can understand that.
Well, part of it is because the judges in rural counties don't see as much crime. The other part is that when you have elected judges, which we do, which I think is a good system, we tend to somewhat reflect the values of the community, the people who elected us. But what they were trying to do was to have judges look at sentencing in certain ways, trying to get them to focus on using prison for more violent offenders.